At the last hearing in Karen Reed's civil case, we heard oral argument on the motion to dismiss. So to understand where we are in Karen Reed's civil case, there was a lengthy stay because of the criminal case. And then once the criminal case was over, now the civil case could continue. There was a motion to dismiss, a 12b6 motion to dismiss that was filed, meaning that there was no answer yet that was filed by Karen Reed's defense team. What normally happens is the plaintiff files a complaint and then the defendant files an answer. Well, in this case, Karen Reed did not file an answer. And what her attorneys did was filed a motion to dismiss, which is also okay if you feel that there are certain counts in the complaint that even if you were to accept everything that the plaintiff said in the complaint as true, still they have not stated a plausible cause of action. So as it relates to certain claims, which we already broke down in other videos, that's where this motion to dismiss was geared towards. I was targeted towards, and that's what we heard oral argument on, and the judge is going to give an opinion, and then after the opinion, then Karen Reed's defense team is going to file an answer to the complaint, and then we're going to get rolling a lot more with discovery. Now, it seems to me that during the discovery phase and perhaps the motion phase throughout discovery in this case, Alan Jackson, he's going to be taking a back seat. That's what it looks like. And if this goes to trial, then that's when Alan Jackson is going to start taking over. That's what it looks like. He said kind of on one of the shows that he's not a civil litigator. He's a trial attorney, and he can try cases, but, the civil litigation is really more for these other firms. But again, he is there and he's watching and he knows how to argue something. And I had some thoughts about the oral argument in the motion to dismiss. I'm sure he had some thoughts also, but I shared my thoughts in previous videos. If you want to go check those out, go ahead and check those out. That was the last video that we did on the Karen Reed civil case. But there was something else that came up in that hearing, and we have to review what happened because there's nothing to do with the motion to dismiss. It has to do with affirmative claims that Karen Reed wants to make against some other individuals, including Tully, Buchanan, and Proctor, etc. So I want Damon Seligson to argue this for you. You'll hear it from him yourself. We'll just play it for a couple of minutes to hear what he has to say. And then we're going to be breaking down these different claims, which he's not so clear about. He just kind of talks about them from like 30,000 feet, but we're going to break them down and go into them today in today's video. But first, let's just kind of hear the 30,000 foot view from Damon Seligson.
As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf.
Now, just to also be clear, I explained already, there's a difference between affirmative claims and affirmative defenses. Very different things. And in my last video, I explained that. We're not going to rehash that now.
Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port.
Okay, so that's the laundry list of the claims that very high level they're going to be eventually filing on behalf of Karen Reed. Now, what Damon Seligson asked for was the normal process. How this is done is that you file a new complaint against all these other third parties, right? Right now in the lawsuit is just the estate of John O'Keefe and the O'Keefe family against Karen Reed, C.F. McCarthy's, and the Waterfall. Those are the only parties part of this litigation right now. And what Damon Seligson is suggesting is that with my answer to the complaint, because they haven't answered yet, right? They only filed that motion to dismiss. Once there's an opinion on this motion to dismiss, then they're going to have to file an answer. With that answer, let us also be able to file a new complaint where Karen Reed will be the plaintiff and all these other people will be the defendants, and it'll be a civil rights case. And now we'll have them all under the umbrella of one case, and we'll all just hash it out together in this one big case. On one side, Karen Reed will be the defendant. On the other side, she'll be the plaintiff. Okay, so that's what he's suggesting to do. Now, practically speaking, that's most likely not going to happen anyway, because most of the time these 1983 lawsuits are removed to federal court. So even if they try to join them, they'll be removed, and then everything's going to be removed. So whether this is actually going to happen or not is a different story. And I don't think the judge is going to grant it anyway. I know people disagree with me, but I have a pretty good track record. So I think you should go with me on that one. So we'll see what happens. But anyway, that's what his suggestion was. But let's kind of go through the causes of action that Karen Reed's going to have against these people that he mentioned in the case. Okay, and we'll see which ones have merit, which ones have less merit. Okay, and maybe they all have merit, maybe they don't. They all don't have merit. Let's take a look. So the first thing that we have to look at is the 1983 law statute. Wouldn't that be a good place to start? So this is the section 1983. We've all heard about it before, and here we go. Every person. I'm going to stop right there because person is actually a very important term that needs to be defined, not just in this statute, but in many different statutes. I know in Michigan, we have some statutes that we have to define. What does it mean? A person, a claimant, all these things have to be defined. So actually what's very interesting is that the state, a state is not considered a person, which is kind of intuitive, right? It's not a person, it's a state. But it gets a little bit interesting because a municipality is considered a person. A city is considered a person, but a state is not. So you cannot sue a state for 1983 because they're not considered a person. So again, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, which is just simply a way of saying who's representing the state. So he's acting under the color of state law. That's what we refer to it. That's the legal term. Acting under the color of state law. That's what it means. It means a police officer dressed in his uniform. He's acting as a police officer when he does this. So that's the first part. Subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. So you have any person who's acting under the color of state law in their official capacity, and they deprive you of your right or privilege, which is guaranteed by the Constitution, which would be anything under the Constitution. So then that person shall be liable to the party injured in that action, suit in equity, or other proper proceeding for redress. So this is basically saying, yeah, you could sue those police officers. If a police officer takes away any sort of constitutional right that you have, then you can sue them. So what 1983 does, the way that you should look at it, is that it simply opens the door. It opens the door, and now you can go and pull out any amendment to the Constitution and say, we're going to sue you under this amendment because 1983 says that we could. All right? So that's how this works. Very, very simply put. So which amendment would be the amendment in this case? What would be the amendment that they would sue? Karen Reed would sue Tully and Buchanan and Proctor, and he did say state of Massachusetts, which we're going to get to because it can't be under section 1983, which we just spoke about. But there's also other claims that could be made. We also heard Brian Albert, Nicole Albert. So let's start with Tully, Buchanan, and Proctor. What claims can we bring for them on behalf of 1983? Which amendment did they violate, or you can allege on behalf of Karen Reed that they violated of Karen Reed's? Which one? The First Amendment? Second Amendment? So the answer here is the Fourth Amendment. The Fourth Amendment is the amendment that you would sue her under. Now, some people would say maybe due process also, but there's a lot of case law on this, and it's very boring, and it's very nerdy and legal, whatever, so we don't have to get into that. I mean, we're law nerds, but we don't have to be that law nerdy. But if you want to, you can go research and you'll see why this is really a Fourth Amendment claim, not really a 14th, which would be a due process claim. So let's just analyze this under the Fourth Amendment. Why is it a Fourth Amendment claim? Well, the Fourth Amendment, right, guarantees that you're not to be subject to unreasonable searches and seizures, right? So seizures would be seizures of what? Your liberty, your freedom. So it's trying to take away somebody's freedom when there's no reason to, that would be a violation of the Fourth Amendment. So this is what we also call under the umbrella of malicious prosecution. So it's malicious prosecution with using the Fourth Amendment. That's basically how this all ties together. So it would be a claim of malicious prosecution under the Fourth Amendment based on Section 1983, how we can get into the door, and that's how you would sue Tully, Buchanan, and Proctor. But let's try to understand whether there can be a case for malicious prosecution. Can there be a case, and how does it all work? So let's start with the first case. Of course, you know, we bring receipts here. That's what we do. We bring the receipts. So here are the receipts. This is the first case. It's a very important case in Massachusetts that talks about 1983 lawsuits. So let's start off for malicious prosecution. To make out a claim for malicious prosecution, a plaintiff must prove, one, the institution of criminal process against the plaintiff with malice. So two things I want you to concentrate on. Number one, the institution, the beginning, the starting. You're starting off the criminal process. That's what the institution of criminal process against the plaintiff with malice. I mean, it has to be that this was with malice. It can't be a mistake, can't be an accident. Oh, whoops, we got the wrong person. There has to be malice behind what you're doing. And the institution, which is an interesting word, which we're going to get to a little bit more, explaining a little bit more later. Number two, without probable cause. Okay, so full stop. This is a hurdle for Karen Reed. Okay, you have to show that they did not have probable cause to arrest you. Now, there's two ways to do that. Number one is you can say that some of the police reports were falsified, right? If the only way that you're able to get a search warrant, or the only way you're able to get someone indicted is by lying on a police report, then that would also constitute that there was no probable cause because it was all based on a lie. Okay, so that's number one. Number two is that even if initially there was probable cause to arrest Karen, which many people can make the argument that, look, initially, without knowing anything more about the investigation other than Karen Reed was drunk the night before and she dropped him off and there was a car there and there's some pieces of taillight, whatever. If you just put those pieces together, and then you can say that maybe there was probable cause to arrest her initially. But what happens if that changes? What happens if initially you arrest someone based on probable cause, and then after you discover more evidence, it turns out that there's no more probable cause. This person says innocent. He's innocent or she's innocent. Then what do you do? And let's say you continue the prosecution. Well, it's reasonable. It would seem very, very reasonable and intuitive that would also constitute malicious prosecution. Now, let's go back to the language of what this started off with. It started off with the institution of criminal process, which almost sounds like that if you just start it with probable cause and then you lose it, that would not be considered malicious prosecution if you continue the prosecution. Now, it doesn't make any sense, but that's just if you're very, very nitpicky and you look at this language, that's what it might be. And I'm going to show you some other language, which is much clearer, that it doesn't just mean the institution, but it can also mean the continuation also of a prosecution that you do not have probable cause for. But even in this opinion itself, you will see that it's not just the institution of criminal process. And I would just like for it to be better. I wish it would have been written better. And I think a lot of the cases that I saw in Massachusetts talk about the institution. They don't say specifically the continuation, even though it seems to be inferred from other parts of the opinions, but it just should have laid it out that way, which I'm going to show you later how it does that in other opinions. Let's continue. So number one, we have number two, without probable cause. Number three, the termination of the criminal proceeding in favor of the plaintiff. That's also a very important part. There has to be a termination of the criminal proceeding in favor of the plaintiff. So, which would be an acquittal. Now, in this case, we know there was not a complete acquittal. There was acquittal on charges 1 and charges 3, but in charge 2, right, she was found guilty of OUI. Is that going to make a difference? So we're going to talk about all this, but we have to break things down one at a time. So let's go back to the probable cause. Okay, malice is very clear. We're going to talk about the institution as opposed to the continuation, but let's see the next part. Generally, where there is probable cause to arrest, the plaintiff has failed to meet the probable cause element of malicious prosecution. But now let's move on to the next part. Look at the last part. Therefore, listen carefully. Therefore, probable cause to arrest may not be conclusive where evidence later surfaces that eliminates probable cause, and the police are involved in pursuing the action despite the discovery of this evidence. So this is where it seems from this opinion that it's adopting the idea that the continuation of a prosecution when you lost the probable cause would also constitute malicious prosecution. So it's not just intuitive, it's not just reasonable, which makes all the sense, all these sense in the world, but it actually seems to be from the case law itself. I just would have liked for it to be that in the elements it would have said it straight out. Now I will show you. Look at this case. This is Blue versus Lopez, and this is in a different. This is a federal case, and it's in I think the 3rd district. So this is not in the same district as Massachusetts in the federal world. But look what it says here. In Wood, we noted, as to the constituent elements of the common law tort of malicious prosecution, this court has looked to both federal and state law and determined how those elements have historically developed. To prove a malicious prosecution claim under federal law and Georgia law, a plaintiff must establish the following. 1, a criminal prosecution instituted or continued. You see how it says that straight out in the elements? A criminal prosecution instituted or continued by the present defendant? That's how I would have liked for Massachusetts to say it. But of course, Massachusetts, they do things differently, and they didn't say it like that, although they should have. And then 2, it's all the same. Really, the rest are the same. So I just wanted to point that out, that you see in this jurisdiction, actually, it said continued straight out, and in this Gutierrez case, which is one of the seminal cases in Massachusetts about 1983, it just says the institution of criminal process. It should have said continued, even though later on, like we showed, it does seem to mean that if they lose probable cause in the middle of the investigation, they have to drop it, which makes, again, all the sense in the world. Okay, so that is as it relates to malicious prosecution. So we still have a little bit of an uphill battle. Number one, you got to argue the case. Maybe they didn't have probable cause initially. Did they have probable cause or not to initially arrest her? Number two, even if they did have an initial probable cause, what about when the ARCA experts got involved? When the ARCA experts come and they say that this is not scientifically possible to figure this, to do this, and all you have is Trooper Paul, at that point, do you lose probable cause? I would definitely hear that you have an argument that you lose probable cause. So that is where this is going to get a little bit interesting. And again, if there are police reports that were doctored, and we know that there are certain affidavits that were filled out by Proctor that was the times were changed. And again, it has to be with malice. So you can't just argue that it was a mistake. You know, if he says it was a mistake, you know, that's you're going to have to argue that it was malicious. So not so clear. But I think the stronger argument is that throughout the discovery of this case, once they started to see all the evidence pointing that Karen Reed is innocent, well, then at some point they may have lost their probable cause, and yet they continued with the prosecution. Okay, so that is the probable cause. Now, the last part about the termination of the criminal proceeding in favor of the plaintiff, we're going to get to a little bit later in the video, about whether the fact that she was convicted of OUI, is that going to affect this case? Because generally speaking, it has to be it has to be an acquittal. You have to be acquitted, right, of this. If you're found guilty, then you can't sue them because obviously there was some probable cause there. They were convicted. Okay, so we're going to get to that in a minute. But when it comes to just another point that I wanted to bring out about this malicious prosecution claim, this 1983 claim, is that what about if you win? If you win, what type of damages are available? So number one, there's obviously damages available for the physical pain and suffering that Karen Reed may have gone through over the course of this prosecution. But there's also something called punitive damages. Punitive damages are available in certain select circumstances, and 1983 against individuals in their own capacity, like Tully, Buchanan, and Proctor, punitive damages would be available. Now, just to understand how this would work, they would not represent themselves. The town of Canton would step up, or the state, they would be represented by a body that has a ton of money. Okay, they're not being represented by themselves. That's what happens. Now, there are certain times where the municipalities try to say that they're not going to represent them, but whatever. Most of the time, they will pick up the representation of these individual police officers. So even though you're suing them in their individual capacity, but there's usually a deal between the police officers that they're not going to hang them out to dry, right? Okay, so that is in terms of, if they get $1 million verdict, they will still have to pay. They're going to have money to pay for that. But on top of the personal injury and the pain and suffering that Karen Reed has gone through, there's also punitive damages. Now, punitive damages are created to punish and deter this conduct. Okay, so generally speaking, let's say you have a regular tort, a regular case of an auto accident. Somebody ran a red light and he was drunk and high, and he was speeding. And so you take this case to the jury. You're not allowed to ask the jury to give you a verdict that punishes the defendant for acting that way. You're not allowed to do that. You're limited to asking for specific elements of damage, which would include pain and suffering, medical bills, non-economic damages, whatever. There's a limited amount of damages that you're allowed to ask the juries for. But one of them specifically you're not allowed to ask for is punitive damages. You're not allowed to ask the jury to punish the defendant. You're not even allowed to make a suggestion that they should send a message with their verdict to this defendant not to drink again and not to drink and drive again. You can't do that. But when it comes to 1983, you are allowed to do that. And punitive damages could be significantly more than what a jury will award for pain and suffering, because it has to punish and it has to deter. That's a very important word. You have to deter this conduct from happening again. Now, is the city going to get deterred from a conduct if you from doing this if you just hit them with $100,000? No, they pay that in 3 minutes to somebody. It has to be significant that the city gets or the county gets the message. It has to be that you're sending a message with your verdict, and that would be included in a 1983 lawsuit. So this would be punitive damages. And again, this is what it says, just to read the case for you. This is from Miga versus Holyoke. Punitive damages are recoverable in a 1983 suit where the defendant's conduct is motivated by an evil motive or intent, or where it involves reckless or callous indifference to the plaintiff's federally protected rights. Okay, so punitive damages is available. Now, there's another claim that he didn't really speak about, but which is potentially a claim that she can bring. And that's something that we call a Monell claim. Okay, a Monell claim is when you sue the city or the municipality for policies and procedures that they had in place, which this conduct arose from. Okay, so this is how it's explained. And again, this is a Massachusetts case. This is how it's explained in the case. To make out a case for municipality liability under 1983, the Supreme Court has repeatedly held that liability can be found only where the municipality itself causes the constitutional violation at issue. Respondent superior or vicarious liability will not attach under 1983. Okay, so that's a different theory of negligence, which we don't really have to get into today, but it's like an employer. Let's say an employer hires an employee and the employee is negligent, so the employer can be responsible for the employee, but that's not how this works. That's not how the city suing a municipality works. It works differently. Thus, a plaintiff must show that a policy or custom of the city led to the constitutional deprivation alleged. Is there a policy, custom, or procedure that was in place in the city of Canton, the town of Canton, the county of Nova, whatever, while all these police officers are working out of, that is what led to the constitutional deprivation of Karen Reed? This requires that plaintiff demonstrate both the existence of a policy or a custom and a causal link between that policy and the constitutional harm. So number one, you have to identify a policy. Where is this policy? Where is this custom? And then once you identify it, so do you have a policy to doctor your police reports? Is that part of the policy? Is that part of the training that you train your officers? By the way, if something's inconvenient or you want to hide something, just change the time when you're saying a car got to the Sally Port. If that's part of the customs and the policies and procedures, then you can get them on a Monell claim. Now, very, very difficult to prove a Monell claim, but a lot of times it's thrown in there anyway, and it gives you a lot more discovery, and you can get some other juicy stuff perhaps from it. But here's also another, again, to show you how high of a burden this is, the Monell claim. Only where a municipality's failure to train its employees in a relevant respect evidences a deliberate indifference. So it has to be that its failure to train its employees shows a deliberate indifference to the rights of its inhabitants. Can such a shortcoming be properly thought of as a city policy or custom that is actionable under Section 1983? So deliberate indifference is very, very high burden, as you can imagine. Only where a failure to train reflects a deliberate or conscious choice by a municipality, a policy as defined by our prior cases, can a city be liable for such failure under Section 1983. So very difficult for a Monell claim. You have to link the policy or custom with the constitutional violation, or the failure to train is deliberately, it shows its evidence is a deliberate indifference to the rights of, let's say in this case, Karen Reed. So it'd be very difficult to prove, but they may just throw it in anyway. And who knows what you're going to find there in city of Canton, the town of Canton. Now, also, just something interesting that you should know is that when it comes to the Monell claim, punitive damages are not allowed. So punitive damages would only be allowed against Tully, Buchanan, and Proctor, but not with a Monell claim. Compounding of public policy concerns, the award was one for punitive damages, a form of relief particularly disfavored when assessed against a public entity. Okay, and recounting a history of municipal immunity from punitive damages. So yeah, you want to sue a municipality, they have immunity from punitive damages. Okay, now let's move on to Brian Albert, Nicole Albert, and Matthew McCabe, Jennifer McCabe, Brian Higgins. Now, they did not mention Colin Albert, and a lot of people are making a big to-do about this. Oh, they didn't mention Colin Albert, which means that they're conceding that he was not at the house at the time and he wasn't involved in the murder. And okay, that's an argument that they can be making. Maybe he forgot it. Maybe he forgot to mention Colin Albert. He maybe didn't mention everybody. Or you can say that maybe they have no interest in going after Colin Albert. After all, he's a little kid. They're going after all the big boys and the big girls. So why do they have to throw Colin Albert into the mix anyway? Because this is just a case for damages, and Colin Albert has no money and no assets. So why would they throw him into the lawsuit? Maybe if Brian Albert and Nicole Albert, they want to bring him into the case also, then they could, but they're not going to, obviously. So it could be that they're just thinking like, what are we going to gain by throwing Colin Albert into the mix as well? We're going to go after him and seize his, I don't know, does he have a car? I'm like, well, what are they going after when it comes to Colin Albert? So it could be that they just felt like it's just not worth our trouble going after Colin Albert when we have all these other people in the suit anyway, and they actually do have money and assets. Okay, so how would we get these people involved in this case? Now, they're not acting under color of state law, right? They're not police officers. So how can they be involved in a Section 1983 lawsuit unless you're going to come up with some other legal theory that you can sue them for? Now, I haven't thought of any. Well, what can you possibly sue them for? What have they done in a tort to Karen? What have they done wrong to Karen Reed? The only thing that you can argue is that they were part of this cover-up, right? You want to argue that they're part of some sort of conspiracy. So do we ever find something where you have, let's say you have an example where a police officer goes over to his friend who's a civilian, and they organize a way that the police is going to arrest this guy and this somebody else, arrest their enemy, and this civilian is going to be part of that conspiracy. So you got the detective or the police officer acting under color of state law. Very clear, he's going to act as a police officer and arrest this guy, but he is also working with this private citizen. Can you then sue the private citizen for 1983? And the answer to that is yes, which is why they're going to be arguing that all these people involved, all these people in the house, were actually working in concert. They were working together with the police to spin this narrative, to pin it on the girl, pin it on Karen Reed, and to get the pressure off of them. And they used all of their connections and clout with the police officers to get the focus off of them. And if they did that, then you can make the argument that they are liable under 1983, because this is what it says right here. The Supreme Court held, and this is again Downs versus Sawtell, the Supreme Court held that the district court had erred in granting summary judgment against the plaintiff and explained the involvement of a state official in a conspiracy with a private party plainly provides the state action essential to show a direct violation of petitioner's 14th Amendment equal protection rights, whether or not the actions of the police were officially authorized or lawful. Moreover, a private party involved in such a conspiracy, even though not an official of the state, can be liable under Section 1983. So this is where you see, this is what he was talking about, the conspiracy to commit this malicious prosecution. If they conspire together with Proctor, if they were talking to Proctor and Buchanan and Tully and encouraging them to go after Karen Reed and get the pressure off of them. And so then, as you see right here, if they're working together, even if they're not an official of the state, they're not officially working under color of state law, but they're part of the conspiracy, well, then you'd be allowed to sue them in the 1983 as a 1983 claim. Okay, so that is as it relates to Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Brian Higgins. All right. Now, he also mentioned some other things. He also mentioned some claims, the Massachusetts State Police for negligent training and supervision. Now, I don't know if he meant to say the Monell claim in this when he was saying Massachusetts State Police, and that would not be against the state. But he did say Massachusetts State Police. And there are some ways in Massachusetts to sue the state police, but you're really not going to get there here. So like I did some research on this, and it's really not a claim that's going to be winning at all. So the fact that you're going to argue that Massachusetts State Police did not train or supervise their police officers, and that's what happened in this case, that's not going to win. You know, they may throw it in there, but it's not going to win. I can just tell you that may even get a 12B6 motion to dismiss right off the bat. So that's as relates to the Massachusetts State Police. And also the town of Canton for negligently securing the Sally Port. That's also not a claim. That's not a plausible claim that can be made. There's just way too much immunity built in to the Massachusetts State Police and the town of Canton when it comes to those. Because these aren't 1983 lawsuits. These 1983 claims. The claim that he's talking about against the Massachusetts State Police, which anyway, 1983, we showed you that can't happen anyway because they're not considered a person. But this other negligent training, negligence is an immunity. They're immune from negligent suits. So you're going to try to sue them in negligence. There's like one very, very narrow category where you can possibly get through, which, again, for all you law nerds, you'll enjoy it, what exactly it is. But let me just say, suffice it to say, it's not present in this case. Okay, so that's the negligent training and supervision for the Massachusetts State Police is not going to go anywhere. And the town of Canton for not securing the Sally Port is not going to go anywhere either. So those I'm not even going to waste too much more time on. But let's talk about the last prong of the malicious prosecution. So we spoke about the malice. We spoke about whether there was probable cause in the beginning or in the middle or in the end, whenever probable cause end, and whenever you lose the probable cause. So that's the second prong. And the third prong was the fact that she was acquitted. She has to be acquitted, but we know that she was found guilty of OUI. So what about that? What about that situation? Would she be able to continue? Because after all, you know, they got a charge to stick. They did get some charge to stick. So there was probable cause for something. So why can't they just say, okay, well, that's a probable cause for everything, and therefore there's nothing to talk about? So look at this case. Okay, so this is Rivera-Marcano. The Rivera-Marcano case. Whether and in what circumstances a plaintiff may maintain a malicious prosecution action based on one groundless accusation when probable cause existed. And by the way, this is a case, by the way, from the federal First Circuit. So this is the First Circuit, which is in Massachusetts. Massachusetts is part of the First Circuit, but this is a federal case. So this is not a state case, it's a federal case. I'm going to show you a state case in a moment, but this is first a federal case. So whether and what circumstances a plaintiff may maintain a malicious prosecution action based on one groundless accusation when probable cause existed for one or more other accusations made concurrently has never been addressed by the Puerto Rico Supreme Court. In other jurisdictions, so this was a case that was appealed from the Puerto Rico Supreme Court. In other jurisdictions, courts have permitted such actions. So listen to what it says here. So again, this is very clearly our situation. You have one, this is what the argument is going to be. The accusation here is going to be, the groundless accusation you're going to argue is the second degree murder. That you're going to argue is groundless. The OUI, maybe you have probable cause on, right? That's what we're going to split it up. The plain OUI, she's operating under the influence because she went to the hospital the next day. They drew her blood. They were able to go backwards and see how high she was when she was driving. Okay, so maybe you got the OUI probable cause, but what about the second degree murder? So this is essentially laying out what would happen in that case. In other jurisdictions, courts have permitted such actions if the charges stem from different sets of facts and if all the other elements of a malicious prosecution claim are fulfilled. So take a look at some of the examples. Holding that plaintiff could maintain a malicious prosecution claim based on groundless charges of resisting arrest and assault, even if probable cause existed for a disorderly conduct charge. So there's different charges, disorderly conduct and resisting arrest and assault. Plaintiff having shown, again, another case that they cite here, plaintiff having shown that defendant maliciously joined an unjustified charge with a justified charge does not have the further burden of showing that her damage was specifically attributable to the malicious prosecution as opposed to the prosecution when the jury found was not malicious. And finally, an action for malicious prosecution should not be available, whereas here, both charges arise out of the same set of circumstances. So, does here the charge arise out of the same set of circumstances? Yes, they kind of do, right? Because she was in the car, she was drinking, or she was drunk at the time when she was driving. The question is, what happened after that? So, number one, you do see it's possible, but the argument you're going to have to make is a little bit tricky. And I want to show you this other case, because this other case, I think, lays out something which can make the argument for Karen Reed very strong. Okay, so take a look at this. And this is a state case. This is a Massachusetts state case. We conclude that a plaintiff's civil action may proceed only where the action is based on facts viewed in the light most favorable to the plaintiff, other than those necessary to sustain the plaintiff's criminal conviction, and where the plaintiff demonstrates that the civil action, if successful, would not necessarily undermine the validity of the plaintiff's prior criminal conviction, which to me, I understand this as meaning, can the civil action and the criminal conviction live in the same world? Or are they directly opposite each other? So, for example, in this case, can you make the case that she was drunk but did not hit John O'Keefe? And of course, the answer is, of course you could. You could make the case that, yes, the criminal conviction of OUI is 100% legitimate, and she did not run over John O'Keefe. So this is the case where I think where you see that even though you have a conviction of the plain OUI, you still would be able to have a 1983 claim based on their investigation into the second-degree murder charge, which they were charging her with. So that was, if you want to make the case that was lacking probable cause, or at some point in the investigation they realized that there was no more probable cause, that is where you can say, okay, still, even though she was convicted of the plain OUI, it's not going to interfere because both can live in the same world. I can live with the fact that she was convicted of OUI, and it still does not contradict the fact that she did not murder John O'Keefe, or there was no probable cause for that. So that's what I think this case stands for, which is why I think this would be a helpful argument for Karen Reed when she eventually files this case. Now, there's one more very important issue that we have to talk about, and that is qualified immunity. Okay, so qualified immunity, we have to understand that because that's an immunity that's given to police officers like Tully, Buchanan, and Proctor. And this is absolutely going to be a defense that they're going to try to use. So what does qualified immunity mean? So it's obviously a very long topic and a little bit of a complicated topic, but we're going to try to make it as simple as possible like we usually do here. So this is from a case, Gauthier versus Crean, Massachusetts state case. Qualified immunity. Government officials are entitled to qualified immunity from Section 1983 claims for damages if their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That is the sentence that you need to analyze. Okay, again, so police officers have immunity for 1983 claims. So that would include Tully, Buchanan, and Proctor. They would have qualified immunity if their conduct does not violate a clearly established constitutional right. Now, that's going to be tough to argue because her constitutional right of unreasonable searches and seizures is pretty strong. That's clearly established. But this is where it gets, the other part is where it gets a little more complicated, of which a reasonable person would have known. So let's continue with this case because it's going to explain it. The determination of qualified immunity follows a two-part test. The first prong asks whether the facts alleged or shown by the plaintiff make out a violation of a constitutional right. Okay, that's the first prong. Do the facts alleged make out a violation of a constitutional right? Obviously, in this case, yes. To be maliciously prosecuted is a Fourth Amendment violation. It's clearly established. Okay. The second prong asks whether that right was clearly established at the time of the defendant's alleged violation. The second step, in turn, has two aspects. One aspect of the analysis focuses on the clarity of the law. Did the police know about this law? Number two, the other aspect focuses, and this is where I think it really is going to come down to, the other aspect focuses more concretely on the facts of the particular case and whether a reasonable defendant would have understood that his conduct violated the plaintiff's constitutional rights. What would a reasonable police officer have done in this situation? If you are in Proctor's shoes, you are running this investigation, what would a reasonable person do Would they continue with the investigation? Would they continue with the prosecution, knowing what he's known? And this is what the argument is going to be from Proctor, Buchanan, and Tully, that if you just take a reasonable police officer in my situation, with everything that we knew at the time, we would have felt that there's probable cause to continue with this prosecution. So that is really, and they're going to argue this qualified immunity, and that's what's going to be the basis of to get out of this 1983 lawsuit. So you're always going to have to deal with qualified immunity, and it is going to be an argument that's going to be made. So I think that that's really where this complaint comes down to, which, again, we're going to see when the judge comes down with that order. Again, my call on that order is that the judge is not going to allow them to answer the complaint and at the same time file a new complaint against all these defendants. Some people disagree with me, but I have a pretty good track record, and I think you can kind of bet on me. So we'll see again. We'll see what happens, what the judge does. But I think the judge is not going to allow them. He's going to say, no, you want to sue them individually, and then maybe you can move to consolidate them, do it like everybody else does. We're not going to make any special exceptions. This extraordinary circumstances or request that you're asking, I don't think we're going to do that. So, but one way or the other, it seems that Karen Reed is getting ready to file this 1983 lawsuit. Like I said, the claim of Massachusetts State Police of negligent training and the negligent securing of the Sally Port are really, really not great claims. They may throw them in there, but they may get dismissed very early on. So there's really, really strong immunity there. And again, it's not a 1983 claim. So I think it's really going to come down to more of the 1983 against Tully, Buchanan, Proctor, and all these other people involved, Brian Albert, Nicole Albert, all those people as well. So that is where it's going to come down to. All right, well, that's going to be it for now. We will see you next time. If you haven't yet, please hit the subscribe button, hit the like button, and we will see you next time.